There is a photograph that the Department of Justice doesn't want you to look at too closely. It was taken in the year 2000. Donald Trump, Melania Trump, then Melania Canals, Jeffrey Epstein, Ghislaine Maxwell, all four of them together smiling at Mar-a-Lago. The DOJ released it, then pulled it down, then put it back up again. And that tells you everything you need to know about what's really happening here, because that photograph, it's the least of what's buried in these files. And right now, the First Lady of the United States is waging a legal war, not to defend her reputation, but to keep you from asking questions. Pay attention to this next part. Let me lay this out for you the way a federal prosecutor would. On January 30th, 2026, the Department of Justice released what it called its final tranche of Epstein files, over 3 million pages, 2,000 videos, 180,000 images. Deputy Attorney General Todd Blanche stood in front of cameras and told the American people that the DOJ was now in full compliance with the Epstein Files Transparency Act, the law Congress passed in November 2025, requiring the release of all unclassified material tied to Jeffrey Epstein's sex trafficking cases. But here's the thing. The DOJ identified over 6 million potentially responsive pages. They released roughly half, the rest withheld. And the explanation they gave Congress was so vague, it might as well have been redacted too. Think about that. We're talking about the most high-profile sex trafficking investigation in American history, and the government is still holding back 2.5 million pages. Why? Now, within those released files, scattered across thousands of documents, the name and image of Melania Trump appears, not because she's been charged with anything, not because she's been accused of criminal conduct, but because she was there. She was in Epstein's orbit. She was photographed with him. She attended events connected to him. She was part of that world. And the moment those connections started becoming public in a serious way, the moment journalists started asking real questions, something shifted. The First Lady's legal team went on the offensive. Not defensive, offensive. Her personal attorney, Alejandro Breto, began sending threatening letters to journalists, to political commentators, to anyone publicly connecting Melania Trump to Jeffrey Epstein's world. The threats were enormous. We're talking $1 billion in damages. $1 billion. Let that sink in. That is not a number you pull out of thin air. That number is designed to do one thing: make people stop talking. And it worked. James Carville apologized and retracted his comments. The Daily Beast retracted an entire story. Multiple media outlets went silent, but one person refused. Author and journalist Michael Wolff, the man who wrote Fire and Fury, The Explosive Trump, White House Expose, Wall did not back down, and as of the time of this recording, no lawsuit has actually been filed against him. See the pattern? The threat is the weapon, not the lawsuit itself. From a prosecutor's perspective, this is textbook. What Melania Trump is deploying here has a specific legal name. It's called a SLAPP action, Strategic Lawsuit Against Public Participation, and it is one of the most aggressive tools available to powerful people who want to shut down speech, not by winning in court, but by making the cost of defending yourself so astronomically high that most people simply go quiet. That is exactly what happened here. That is the goal. This is not one lawsuit. This is a coordinated legal suppression campaign run out of the East Wing of the White House, designed to silence reporting on the First Lady's connection to the most dangerous sex trafficking operation in American history. Now, let me tell you what Michael Wolff knows and why Melania Trump's attorneys are so desperate to silence him. Wolff interviewed Jeffrey Epstein extensively before his death in 2019. He has reported on the record that Melania Trump was, in his words, involved in Epstein's social circle. He has reported that Epstein himself told him that Donald Trump first had sex with Melania on Epstein's private jet, the so-called Lolita Express. When Wall started making these statements publicly, in podcasts, in interviews, Melania Trump's attorneys sent him a letter threatening $1 billion lawsuit. They demanded he retract. They demanded an apology. Wall said no. On October 22, 2025, Wall filed a preemptive lawsuit in the Supreme Court of the state of New York. It's called an anti-SLAPP action, seeking a declaratory judgment that his statements are protected speech under the First Amendment. And here's the critical legal move that changes everything. That filing gives Wall subpoena power. Subpoena power. Do you understand what that means? It means Wolff can now compel testimony. He can put people under oath. He can force them into depositions. And he has said on the record that he wants nothing more than to depose both Donald Trump and Melania Trump about their relationship with Jeffrey Epstein. From a prosecutor's perspective, this is what we call a discovery trap. Melania Trump's own legal threat designed to silence a journalist has now handed that journalist the legal tools to force sworn testimony out of the White House. This changes the legal landscape entirely. But it gets more complicated because Melania Trump's team has now hired DLA Piper, one of the largest and most powerful law firms in the world, and is attempting to move the case from New York State Court into federal court. Why would they do that? Because federal court procedures are different. The timeline is different. The discovery rules are different. The judges are different, and the process of actually serving the lawsuit has been, according to Wolff, deliberately obstructed. One process server refused to take the case. A second couldn't locate Melania Trump to serve the papers. Think about what that means. The First Lady of the United States is, by all accounts, making herself legally unreachable for a lawful legal process. She is avoiding service in a case she initiated. Let me say that again. She threatened Wolff with a lawsuit, and now she's dodging the process server. So that lawsuit can't move forward. Why? Because once it moves forward, discovery begins, and discovery is where secrets die. Now let me put this in context, because this is not happening in a vacuum. The Epstein Files Transparency Act was signed into law by Donald Trump himself on November 18, 2025. It required the DOJ to release all unclassified files by December 19, 2025. The DOJ missed that deadline. By early January 2026, less than 1% of the files had been released. A 119-page grand jury document from New York, completely redacted. Black page after black page, hundreds of pages blacked out entirely. And the DOJ's own internal redaction process was so inconsistent that the same name would appear unredacted in one document and blacked out in another. Faulty redaction techniques allowed the public to recover content officials intended to hide. This is not the behavior of an institution that wants transparency. This is the behavior of an institution that is managing a political crisis. Deputy AG Todd Blanche, who, let me remind you, was Donald Trump's personal defense attorney before taking this job, stood up in front of cameras and told the American people that the White House had no oversight over the review or the redactions, that no one was being protected, that the process was clean. But here is what a prosecutor looks at the pattern. The DOJ identified 6 million pages. They released 3.5 million. 2.5 million remain out of public view. The DOJ's own legal obligation under the Transparency Act requires them to explain every single redaction to Congress, covering roughly 200,000 pages within 2 weeks of the final release. They have not done that. Meanwhile, a September 2025 poll showed that 90% of Americans wanted the files released in full. A January 2026 poll showed that 56% disapproved of how Trump handled the investigation. And 2/3 of Americans told pollsters they believed the government was deliberately withholding information. Now add the Melania layer. The First Lady's aggressive legal posture, the billion-dollar threats, the retractions she's already secured from journalists, the hiring of a top-tier law firm to fight Wolff's lawsuit. All of this is happening simultaneously with the DOJ's own resistance to full transparency. The East Wing is running a parallel suppression campaign to the one the West Wing is running through the DOJ. From a prosecutor's perspective, you don't see that kind of coordination unless the stakes are genuinely high. And the stakes here are simple. Keep the full scope of the Trump's relationship with Jeffrey Epstein out of sworn public testimony. Because once you are under oath, once a judge is watching, you cannot lie and you cannot dodge. So what does this mean going forward? First, the Wolff lawsuit is not going away. Even with DLA Piper, even with the removal attempt to federal court, Wolff has raised over $775,000 to fund this fight. He has subpoena power under New York state law. And he has a clear legal argument. You cannot threaten a journalist with $1 billion lawsuit to silence reporting on a matter of extraordinary public interest. New York's anti-SLAPP statute exists precisely to prevent this kind of abuse. Second, the Epstein files are not closed. 2.5 million pages remain unreleased. The grand jury materials are still largely sealed. Democratic members of Congress, including Representative Ro Khanna, have already raised the question publicly: why is the DOJ withholding half the files it identified? Representative Summer Lee introduced an amendment to hold Attorney General Pam Bondi in contempt of Congress for failing to comply with the law. It failed along party lines, but the legal question remains on the record. Third, and this is what matters most, the First Lady's legal strategy may have backfired in a way her team did not anticipate. By threatening Wolff, she did not silence him. She activated him. She gave him a courtroom. She gave him discovery tools. And she gave the American public a front-row seat to a legal fight that is at its core about accountability. This is bigger than one case. This is about whether the most powerful people in this country can use the threat of litigation to wall off the public from the truth. Whether a sitting First Lady can direct her attorneys to silence journalists, while the DOJ simultaneously withholds millions of pages of federal criminal investigation files. From a prosecutor's perspective, we know what obstruction looks like. We know what intimidation looks like. We know what a coordinated effort to suppress information looks like. We are watching it happen in real time. The Wolff case is in its early stages. The Epstein files are still being analyzed, and the full legal and political consequences of what we are seeing have not yet materialized, but the documents are out there. The court filings are on the record, and the pattern is clear to anyone willing to look at it the way a federal prosecutor would. Not through the lens of politics, but through the lens of the law. Stay informed. The truth is still.